Welcome back to Boca Raton Injury Law with Mike Grife. I'm Abby, and today I'm here with Mike Grife from the Grife Law Firm. Good to have you back, Mike.
Good to be back, Abby.
Today we are taking on one of the most misunderstood ideas in injury law. When you are hurt by care at a hospital, the hospital itself is very often the real defendant, not just the doctor. We will cover who you actually sue, the doctrines that reach the institution even when the ER doctor is labeled as independent contractor, how a Florida hospital case is proven, what it is worth, and the deadlines that quietly end these claims. If a hospital is in Boca Raton or anywhere in Palm Beach County harmed your family, this one is for you. So getting into question one, most people assume the doctor is the only target after something goes wrong in the ER. When you're injured due to negligence at a Boca Raton hospital, who can be sued? The doctor, the hospital, or both?
That is a great question, Abby. And we're really getting into an area of law that I'm very passionate about, medical malpractice. I think this is an area that's extraordinarily specialized in the state of Florida and really throughout the country. It's a lot more complex than an auto accident case, even a trucking accident case. Medical malpractice is next level legal issues that very few plaintiff advocates and practitioners practice in. When it comes to who could be at fault for an ER doctor making a mistake, falling below the standard of care, this is a very interesting question, and it's an interesting part of the law. So obviously you have any doctor, his or herself, is certainly responsible for their own actions. Now the doctors sometimes, as you're alluding to here, the hospitals try to label them as independent contractors. So the hospital, Delray Medical Center, St. Mary's, HCA, all these different hospitals, JFK, they will sometimes contract with third parties that are essentially the equivalent of staffing agencies that will provide ER doctors to the hospitals. And those doctors sometimes are actually employees of the staffing agency rather than the hospital. So certainly you have liability against the doctor. You have liability against the doctor's employer if that employer is not part of the hospital or is not the hospital corporation. So sometimes you have Infinet or Envision. These are sometimes corporations that employ these ER doctors. So you have liability against the ER doctor, liability against the corporate employer. And then as you alluded to, you also have liability against the hospital, right? Because there's different legal theories such as agency, apparent agency, non-delegable duty. There are all different legal theories with which you could hold the hospital responsible for the negligent actions of the emergency department doctor. Now, as a quick aside, I want everyone out there to know that when you have nursing negligence, because that's also very common, nurses, they have a tough job, but they're human and they make mistakes. And when they make mistakes, just like the rest of us in society, they have to be held accountable. So a lot of times the nurses are employees of the hospital, which makes it a direct negligence claim. The hospital is automatically vicariously liable. For the ER doctor, there are the theories that we talked about, actual agency, apparent agency, and non-delegable duty, whereby you could hold a hospital corporation responsible for the negligent actions of the ER doctor.
A lot of patients are surprised to learn the ER doctor, may not even work for the hospital. So what does it mean that many ER doctors are independent contractors rather than hospital employees?
Yeah, Abby, I would call it a shell game. So I think it's a shell game that a lot of these hospitals try to use to try to say, hey, come to our ER. We have the best doctors. We have the best nurses. You're going to get the best care. But then when those doctors screw up, they want to say, whoa, these aren't my employees. Go after their employer. These are just contractors. So the law recognizes that people, the everyday person out there, the consumer, is relying upon these advertisements and statements by these hospitals advertising the prowess of their ER doctors, how amazing the care they're going to get in the emergency department will be. But then when mistakes happen and catastrophic mistakes happen and people are seriously harmed or even die because of the negligence of these ER doctors, they say they're not our employees. So I would say 100 times out of 100, any times that I've had a client who's harmed by an ER doctor and you explain these intricacies, they have no idea that these doctors aren't employees of the hospital, because everyone says, I'm going to Delray Medical Center. Obviously, the doctors there are employed by Delray Medical Center, or Delray Medical Center is holding them out as their employees when they say, hey, come to our emergency department, you're going to get great care. So there's a lot of a shell game that needs to be completely unraveled to hold the hospitals accountable. And that's at the Grife Law Firm exactly what we do, is to the fullest extent of the law, analyze the facts and circumstances regarding the hospital's admissions, their advertising, why the client went to that hospital, what was said to them, why they decided to get care at that hospital, so that under the law, these hospitals can be held accountable for the emergency department doctors when they're negligent.
Yeah, what you've explained feels like a loophole, and people want to know if the hospital really gets off that easy. So, can you get more into how a hospital can still be on the hook for an independent contractor, ER doctor, under a parent agency?
Absolutely. And we look to close that loophole and close it on the hospitals, which is righteous, which is just, which is what should happen. So again, there's quite a few theories. One theory is called non-delegable duty. There's case law out there in the state of Florida from the 4th District Court of Appeal, which is the Court of Appeal for Broward and Palm Beach County, really where I'm located here in South Florida, beautiful, sunny South Florida. So this line of cases under non-delegable duty holds that because hospitals have this very important job of providing emergency medical services to people when they're at their most vulnerable, right? Because people who show up at the emergency department are normally undergoing a very serious medical condition, and they're not there to barter or bargain and say, oh, if these doctors aren't your employees, then I'm going to leave and go somewhere else. They normally don't have the time for that, right? So the law basically says because these hospitals, and there's all these administrative rules and regulations promulgated by Florida that govern these emergency departments, because of this very important duty, they have a non-delegable duty to provide non-negligent emergent care. So that's what the 4th DCA here in Palm Beach County, the 4th District Court of Appeals, that's their most recent case law of what they've passed. So that's one area or one theory of law where we could hold the hospitals accountable for the emergency department doctors. Another legal theory is called apparent agency. There's 3 elements of apparent agency that one must prove. The first element is a representation by the hospital, say through their advertising, through statements made by hospital employees like nurses, triage nurses, emergency department nurses, et cetera, a representation that someone is going to act on behalf of the hospital, meaning the emergency department doctor. The patient then accepts medical care, changes position and accepts medical care based upon that representation. So they rely upon that representation. The third element being that there's harm that's suffered as a result of that representation. Examples, advertisements on the website, billboards, etc. We provide amazing emergency department care. Our emergency department doctors are amazing. You can rely on us. You can rely on our doctors and staff to provide you with excellent medical care. The person sees that, relies upon that, goes to the hospital, and then suffers harm. Sometimes it's a statement made by the triage nurse or the ER nurse. Hey, relax, everything's going to be great. You're going to be seeing Dr. Smith. Dr. Smith is an amazing doctor. He's one of ours. He's one of our best, things like that. So that's apparent agency, statements made by the hospital employees, what have you, holding these doctors out to be their own. The patient relying upon that and then suffering harm. The third theory with which we could hold a hospital responsible is actual agency, meaning that we don't care if you try to call these doctors independent contractors. You have so many rules, regulations, staff guidelines, policies and procedures on how to practice medicine, how to do stroke alerts, what to do if there's a heart attack or an acute myocardial infarction. All these policies and procedures that these doctors have to follow that are yours, in addition to the staff rules and guidelines. And in addition to the fact that these doctors also might even sit on these administrative staffs, like he's the chief of staff of emergency medicine. Hey, you're an agent of the hospital, period. So the actual agency, if we don't care what you try to call these doctors, there's so much smoke out there. There's so much evidence out there that you're actually controlling these doctors that you should be held responsible vicariously for them.
The term apparent agency sounds like fine print, but it decides the case. What is apparent agency and how does it pull the hospital into the case?
Yeah, so apparent agency is a very valuable legal theory for patients. And it's not just emergency department doctors, it could be a lot of the doctors that treat a patient after they're admitted to the hospital. And again, it could start with the emergency department physician, but it could apply to surgeons, radiologists, any doctor really without a pre existing relationship to the patient, right? It's a different story if, hey, I was treating with Dr. Smith at his office and he's been treating me for years. And then I went to the hospital and he made a mistake. Even then, there could be agency, but under different theories, probably. When you're talking about apparent agency, which is, again, the three elements are a representation by the principal, meaning in this case, the hospital or a hospital employee, through advertising or through statements made by a hospital employee, holding the doctor out as one of their own, as representing the hospital, acting on behalf of the hospital. Then the second element is a reliance upon that representation. So a patient goes into the emergency department, a nurse says, hey, this doctor is one of our best, you're going to really like him or you're going to really like her, whatever, or advertisement seen on a website or a billboard or a TV commercial or a commercial on social media, what have you, where the hospital holds the doctors out to act on their behalf. And again, not just emergency department doctors, radiologists, surgeons, anyone who really didn't have a pre-existing relationship with the patient before they went to the hospital. So in other words, someone comes in, they're having stomach issues, turns out they need some kind of emergency gastrosurgery or even just an elective gastrosurgery, and the hospital brings in someone that they introduce the patient to. That can be apparent agency, right? Same thing maybe with people who read scans, what have you, radiologists. The second element is the patient relies upon those representations. Hey, this surgeon is one of our best. Hey, he does a great job for the hospital and for our patients. Okay. And then you rely upon that, right? The patient relies upon that representation to accept care from that doctor. And then the third element is that the patient suffers harm because of that reliance. Okay. And it all ties together beautifully. It's a representation by the principal, the hospital, through advertising, commercials, statements made by nurses, or statements made by hospital employees. The patient relies upon those representations to accept medical treatment from those doctors, and then they suffer a harm. And again, it's not just emergency department doctors. It could be really any doctor who treats you in the hospital setting.
So the defendant is often the institution, not just the doctor. Now, to the doctrines that make that stick. People hear corporate negligence and assume it just means one bad doctor. What is corporate negligence and how is it different from one provider's single mistake?
So corporate negligence in the medical malpractice setting could mean a lot of things, okay? Hospitals have to have proper policies and procedures to run the hospital, to make sure that the patient gets safe care, to make sure that things like PICC lines are sterilized and they're not dangerous or harmful, to make sure that there are proper protocols in place if a patient's having a stroke or a heart attack or other sort of medical emergencies, to have proper staffing, to have all of these sorts of things. So when you talk about the administrative job of running a hospital, if the hospitals don't do that correctly, if they run afoul and they deviate from their own standards that should be enforceable on the hospital level, then that could be corporate negligence in terms of the hospital corporation itself is not doing its job to make sure that the patient is protected. They have a duty of oversight to make sure that you don't have dangerous doctors on staff, right? If a doctor is known to have been intoxicated and operating on patients and things like that or whatever, they can't be allowed to operate on patients at the hospital. So if you have bad doctors that you know are bad doctors and things of that nature, or your ER is not properly staffed, there's all kinds of corporate responsibility for hospitals on the decision-making level, the policy level, the staffing level, where you can hold hospitals responsible in addition to just the bad acts of a doctor or nurse but the hospital itself on a corporate level has to be held responsible for harm to their patients when they drop the ball.
Yeah, patients rarely think about who let a dangerous provider through the door in the first place. How does negligent credentialing let a hospital be sued for who is allowed to practice?
Yeah, so negligent credentialing is a very interesting facet of law when you're talking about medical malpractice and patient safety and patient rights. Hospitals control the right to say who can treat patients at their facility, right? It's if you think about joining a club or like a country club or what have you, and that country club has a right to say, hey, you're going to become a member or you're not going to become a member. So hospitals, you can't just say, hey, I'm a doctor, I'm licensed in Florida, I want to come to Delray Medical Center or Boca Raton Regional Hospital and operate on patients. Good with you? Okay, cool. Doesn't work that way. The doctors have to go through a whole credentialing process, right? Where they have to get credentials to be able to practice medicine at these facilities. And the job of the hospital is to make sure that bad doctors don't get on staff at that facility. They have to do background checks. They have to do interviews. They have to go and find out, get references from people who know these doctors. They have to look into the doctor's history. Let's just say the doctor was licensed in Massachusetts or New York or where have you, and they had their license suspended or revoked, or they were under many administrative complaints from patients for safety issues, things of this nature. Maybe they were intoxicated when they were treating patients, right? There's all kinds of things that hospitals have to look into to make sure that only good doctors, safe doctors, people who are going to provide good medical treatment and care are on staff at their facility. And if a hospital doesn't do that, if they let a known bad doctor join their staff, or if while the doctor is on staff, they behave in such a way that makes his or her credentials very suspect, or the hospital has a reasonable belief that they're not going to provide safe and cautious and proper medical treatment to their patients, they then have to take action to get that doctor off staff, whether it's suspension or revoking the privileges and things of that nature. So negligent credentialing, and it falls under the medical malpractice pre-suit screening and things like that, where for the most part, you have to get an expert in medical credentialing who's sat on these credentialing boards for hospitals. I brought these cases before. They're very interesting. And you have an expert basically say, hey, look, this doctor never should have been allowed to be on staff at this hospital, or if they are on staff, they should have had their privileges suspended or revoked because of these known bad acts.
Then nurses and techs are also everywhere in a hospital stay, and families want to know who answers for them. So what is vicarious liability, and when is a hospital responsible for its nurses and staff?
So, Abby, here in Florida, we have a theory called respondeat superior, which basically means that an employer is vicariously responsible for the acts of its employee when acting within the scope of its authority or employment. So, as mentioned earlier, a lot of these nurses, techs, et cetera, so forth, they're hospital employees. Unlike some of these doctors where they try to do this loophole, like you were saying, where they say, hey, they're independent contractors, the nurses and techs are directly employees of the hospital. So the hospital has to answer for their employees who injure their patients or who don't take proper care of their patients, who don't do enough, because nurses aren't potted plants, right? They have to use their own clinical judgment. These are medical professionals also, and they're held to a standard of care. So if these nurses don't advocate for their patient, if these nurses do something that harms their patient, if they don't act as the reasonably careful nurse would, okay, then they are held responsible, and so is their employer, aka the hospital. So that's who answers for the nurse and medical techs and things like that. And we brought many of these cases before and had a great deal of success. So happy to answer any questions anyone has out there about it.
After all of that, the practical question is whether you can actually name the hospital itself. So can you sue a hospital directly in Florida, and what has to be true to do it?
All the time. We sue hospitals and we name them as defendants all the time. That's absolutely the proper way to do it. That's the way that we do it. So again, and we've kind of talked about, and just for everybody out there listening, it's you always want to have a hospital defendant when you can. Okay. So the way that you could do it is through the doctors, right? Under the theories of agency, apparent agency, non-delegable duty. And what's really interesting, Abby, since I've become an attorney and started practicing in medical malpractice close to 20 years ago, is the proliferation, and it's a good thing for the patient. A lot of these doctors are now employees of the hospital directly or of a large hospital group. So that's a really great development because you're not talking about mom and pop doctor shop. You're talking about a huge conglomerate, a huge corporation that these doctors work for that's now vicariously responsible with direct negligence. You don't have to worry at that point about apparent agency, actual agency, non-delegable duty. It's direct negligence because they're employees of a big hospital system. You always want to name the hospital. And again, for the doctor, if they're a direct employee, great. Otherwise, you have the apparent agency, actual agency, or non-delegable duty. Then for the nurses and the hospital techs, they're almost always direct employees of the hospital. So that's great. But then you also have, as we talked about, the corporate level of a hospital. Are they behaving and are they acting as a reasonably careful hospital would to protect the safety and the life of their patients on an administrative level, on a staffing level, on all sorts of levels, policies and procedures, so forth. So yes, we always name the hospital. Yes, the hospital is vicariously liable or responsible for the negligence, for the most part, of the doctors, nurses, techs, and their own negligence of how they carry out their duties as a hospital.
Thank you for explaining how the hospital gets pulled in. So next, let's talk about how you actually prove the case in Florida. So families want to know if what happened to them is the kind of thing that becomes a case. What kinds of ER mistakes make most often turn into hospital negligence claims?
Yeah, so there's a lot of mistakes that these ER doctors make that turns into medical negligence claims. I think the most common one that I see is misdiagnosis. Somebody comes in with a very serious medical condition, a stroke, a heart attack, a blockage of their internal organs, and the ER doctor, without performing the proper tests, without doing the proper workup, dismisses it as something very minor, and then discharges the patient, and they suffer catastrophic harm. I see that, unfortunately, all the time as a mistake that these ER doctors make that causes really bad outcomes, bad circumstances. I've had missed stroke diagnoses, missed heart attack diagnoses, all kinds of really bad mistakes that these ER doctors make. And they're not close calls even. I send them to my expert and they almost can't believe that the proper workup wasn't done. Sometimes it's actually by the radiologist in the emergency department. I've had plenty of these cases where the ER doctor sends for certain scans, a CT of the neck, an echocardiogram, what have you, and the person reading those scans, the specialist, they miss it, right? So that happens a lot too, and that opens up a lot of also legal doors that we've been talking about, agency, apparent agency, non-delegable duty. So you see a lot of misdiagnosis. You also see a delay in diagnosis, right? Where the ER doctor thinks there's something wrong, but he doesn't call it right or she doesn't call it right. They admit the patient under a different diagnosis, and then it's later discovered. But by the time it's discovered, the horse is out of the barn, right? And the patient's already going to suffer tremendous harm. You see a delay in diagnosis as well as misdiagnosis. Those are very common mistakes that you see ER doctors make. And then, of course, discharging a patient when they should have been admitted, not getting the right sort of tests and things like that. And that's all kind of part and parcel of that.
So let's talk about how a crowded, short-staffed ER feels chaotic, but people wonder when that chaos becomes negligence. So how do understaffing and triage failures in the emergency room become negligence?
Yeah, so as they say, haste makes waste. You talk about profits over safety and things like that. So when you have a short-staffed hospital And these people are doing double, triple, quadruple duty to try to triage patients, diagnose patients, do whatever they're needing to do to provide treatment. They don't have the time to really dedicate to patient focused care. And therefore, they're in a rush. They have all these patients waiting, all these people waiting, and they have mandates about how many patients they need to see per hour, a lot of times, these ER doctors, because there really is a lot of profits over safety attitudes going on by these hospital, by the boards and people who are like really the bean counters and everything, the people who are really worried about profits versus safety. Okay. But when you're understaffed as a hospital, it's one of the worst things you could do for the everyday person, for members of the public, right? Because again, they're now trying to do the job of 2, 3, 4, 5 people, and the patient safety gets completely lost in the shuffle. A lot of the details, the devil's in the details, a lot of the details that go into patient care, like lab results, you have a constellation of symptoms that maybe one symptom alone is a little ambiguous, but when you look at 3 or 4 symptoms that the patient's exhibiting and you connect the dots, the diagnosis becomes easy, but it's missed because instead of connecting the dots, the doctor is running to the next patient and the patient after that, same with the nurse. So understaffing is a very common and unfortunate problem with these hospitals that should be addressed very quickly.
Everyone hears the phrase standard of care, but few know what it really means in court. What is the standard of care for Boca Raton, Florida, ER, and how is a departure from it proven?
So, standard of care is acting as the reasonably careful doctor. In other words, making sure that the doctor is acting and doing things that the reasonably careful doctor would do and not doing things that the reasonably careful doctor wouldn't do. Okay. And when a doctor deviates from the standard of care, meaning the doctor did something or missed something that the reasonably careful doctor wouldn't, okay, or the doctor didn't do something like order a test or make a diagnosis or order a medication or an expert consult. That's another thing is these ER doctors, with all respect, are the jack of all trades, master of none. So that's why these ER doctors have at their disposal when you're talking about South Florida, right? We're not talking about like a rural place here. We're talking about Broward County, Palm Beach County, Miami-Dade, Martin County. These ER doctors all have at their disposal experts, cardiologists, neurologists, gastroenterologists that they can consult with, right? So that's another way that doctors get negligent is they don't make the proper expert consultation. But when there's a deviation from the standard of care, that's when the doctor is negligent. And there's really a lot of elements that you have to connect. You have to have a deviation from the standard of care, and then you have to have damages, meaning the patient suffered a fairly catastrophic fallout. And then you have to have causation, that the doctor's negligence caused the damages that you're complaining of. But deviation of standard of care or standard of care is really just a fancy way of saying the doctor didn't act as the reasonably careful medical provider would.
Florida has a pre-suit process that trips up people who try and handle this alone. So how does Florida's Chapter 766 pre-suit notice apply when the defendant is a hospital?
That's a great question, Abby. And you're right. A lot of lawyers who don't specialize in medical malpractice and try to moonlight or try to just get as many medical malpractice cases as they can, they fall short because Florida's medical malpractice pre-suit screening is a complex area. I've actually been fortunate enough to lecture in this area. It's a very complex set of rules and statutes that if you don't dot your I's and cross your T's, your case is going to get dismissed. Okay. So whether it's a hospital or a doctor, and I know your question is about a hospital, so let's focus on that for a second. What the law requires is that you get an expert affidavit from a doctor in the same specialty as the doctor who you wish to sue, confirming that there's negligence. Okay. Now, in a hospital setting, it could be an affidavit from a doctor in the same specialty as the doctor you're trying to sue that the hospital is vicariously liable for. Or if it's an administrative issue like staffing, credentialing, policies and procedures, and the inadequacy of what the hospital itself did, you have to find a doctor who has that same position at a different hospital who has the credentials to issue such an affidavit, right? So you have to get an affidavit from a doctor in the same specialty as the doctor that you want to sue, or the hospital staffing personnel that you want to sue for who you think dropped the ball. You have to take that affidavit along with what's called a notice of intent to initiate medical malpractice litigation, along with an authorization for release of protected healthcare information, and all the medical records or documents that your expert relied upon, and serve that upon the defendant hospital. And then that kicks off a 90-day medical malpractice pre-suit screening process, during which the sides can conduct informal discovery that's completely confidential, can't be used down the road. The affidavit also can't be used down the road, but it's almost like a certificate of merit, as if the law wants to say, hey, some lawyer sitting in his office can't just dream up a case. It has to be blessed by a doctor in the same specialty as the doctor or administrative staff that you want to sue. So it's a very complex area of law. And I just want everyone out there listening to know that we at the Grife Law Firm specialize in medical malpractice. This is what we do. These are the people that we protect. These are the people who we right the wrongs for, people who are the victims of medical negligence, whether on a hospital level, a doctor level, a nursing level, what have you. And don't ever be fooled by these wannabe fly-by-night firms that advertise medical malpractice so that they can get you in their door and then refer you to someone like me. Cut out the middleman. Go directly to the specialist. We're going to give you the right opinion about your case, and we're going to be in the best position to do a really great job for you with the level of expertise required of a medical malpractice lawyer here in Florida.
So you've helped us understand how the case is built. Now the next question becomes what it is worth and where the money comes from. So families bracing for a long fight want to understand where a real recovery even comes from. So how does the hospital often become where the real money in a catastrophic case is recovered?
Yeah, so the answer to that is pretty simple, is the hospital is the big, huge corporation, right? So a lot of these doctors, people think, oh, doctors are really wealthy and things like that. And some of them really are. Some of them are very wealthy. Some of them aren't. Some of them make this sort of living that wouldn't allow us to recover for the harm that they inflict upon their patients, okay? So unlike an individual doctor and all of the creditor protections that we have here in Florida, like the homestead laws that you can't put a lien or basically get someone's property when it's their primary property. There's head of household protections over certain assets and things like that. So in Florida, there's a lot of protections for people so you can't go after them individually. But these doctors have insurance policies like people have for their cars or what have you. They have malpractice insurance, although it's not required in Florida. And we should talk about that at some point. But the hospital you're talking about HCA, Tenet, Baptist Health. You're talking about big, huge corporations that own dozens of hospitals in some occasions, or certainly many different hospitals. So when you talk about getting judgments, as you can get in medical malpractice cases for 5, 10, 20, 30, 40 million dollars, right? Who's going to be able to pay those judgments? It's the hospital that's going to be able to pay them, okay? So that's why the lion's share of large recoveries, and of course, in relation to the harm inflicted, is against the hospital, because they're the ones who could afford to pay it, right? Dr. Smith, who unfortunately is negligent and kills his patient, he might not have $25 million or $30 million to pay a judgment, but the hospital corporation will. So that's why in terms of the large recoveries, a lot of times they're against the hospital for that reason.
And when the harm is catastrophic, people might not have a reference for what that is worth. So what damages are available when hospital negligence causes catastrophic harm?
That's another great question, Abby. You're definitely on fire today. And I would say there's really two answers to that. I'm going to break this down into two separate categories. One is a catastrophic harm case where the patient lives, right? Let's just say they suffer a devastating brain injury and they're going to be in a minimally conscious state for the rest of their life, or they suffer paralysis, okay? So in those sort of cases, you get your past and future medical bills and attendant care, which includes not only just like around the clock nursing, all the doctor appointments, but also things like transportation. So you need like a handicap van for a wheelchair access. You need wheelchairs themselves, hospital beds, medical equipment, gauze pads, all kinds of things. Or if they're going to unfortunately have to go to a facility because there's no one who can care for them at home, then the cost of that facility for the rest of their lives, because this is the patient's one shot at justice, right? So this result has to last them forever, a lifetime. So medical bills and attendant care bills, and of course also for like the home health aides themselves and nurses, doctors, everything that flows from the medical negligence and the harm created on the medical bill, attendant care, medical equipment side, housing side. If let's just say someone's home has to now become handicap friendly, so they have to have ADA compliance and things like that. You have to widen the doorways. We have to build a whole new bathroom on the first floor because they can't go up and down stairs, and the only bathrooms with showers are on the second floor, what have you. So everything like that is included, of course, in addition to pain and suffering, loss of capacity for enjoyment of life, mental anguish, inconvenience, lost wages, and earning capacity. So you're talking about lucrative claims that have to be worked up the right way with the right experts, with life care planners, doctors with great credentials who are believable, who are likable, who know how to convey things to a jury in a relatively simple way so that it could be understood by everyone. So those are the damages allowed in catastrophic injury cases where the patient survives. They're crippled or they're extraordinarily deficited, but they survive. The other category is wrongful death, right? So there you're talking about a whole different set of damages. You're talking about loss of net accumulations to the estate, meaning what money would have been left over by this person if they were allowed to work a full work life and they passed away of natural causes. So that's almost like lost wages and earning capacity in a way, but we call it loss of net accumulations to the estate. You're talking about also the survivors, right? So the spouse, the surviving spouse, and their children, at least if they're under the age of 25 in medical malpractice settings. You're talking about their mental anguish from losing their spouse or their parent. Loss of companionship, loss of protection is also available for the survivors in the past and in the future. And then you have loss of support and services, which is interesting because it's not only like what could be calculated in terms of, hey, my husband or wife used to do this around the house or used to do this for the kids, and now I have to pay someone to do that or whatever. Even if the survivor has now undertaken that duty. For example, someone's husband used to do all of mow the lawn and take care of all that, but now one of the children has to do it or the wife has to do it. That's all collectible under loss of support and services, cooking, cleaning, shopping, household duties, childcare, things of that nature. And then you need, again, a team of really good, dedicated, qualified experts, normally economists, to add all that stuff up. So medical malpractice gets so complicated when it comes to catastrophic injury cases, but we're just the firm for the job. We've been doing these cases for decades. We have board certified civil trial attorneys. We've tried medical malpractice cases. We've hit medical malpractice verdicts. We're really good at what we do because we're so dedicated to take care of our clients and provide them with exemplary legal services. But yeah, I think those are really the damages when you talk about catastrophic cases.
Wow, that is a lot to think about. And people might have some confusion whether Florida caps what a jury can award. So why is there no cap on non-economic damages in a Florida hospital case?
Because justice is good, because that is righteous, because that is right, because some lawmakers in Tallahassee shouldn't tell a jury in Palm Beach County what a case is worth. We should leave this to the good judgment of our jurors out there who get most cases right. They don't get every case right, but they get most cases right. And if a jury hears all the evidence and determines that a patient or a survivor in a wrongful death case is determined to a certain amount of money for catastrophic and horrible harms that were inflicted upon the patient or the surviving family member now has to deal with because of the loss of the patient, then no lawmaker should tell us, hey, we understand that you think that there was $1 million in harm, but we can only limit that to 250,000. That is unjust. That is unrighteous. And frankly, that's un-American. As Americans, we believe in the jury system, right? For the most part, we're capitalists. We kind of believe in right and wrong. I think a lot of Americans have a very strong belief in wrong, and we know the difference in how people should act. So when you have a negligent doctor or hospital that commits wrongs, okay, then a jury should be able to hear that evidence and award the amount of damages to make it right, to right the wrongs committed. There should be no caps on these. The Supreme Court very astutely said that it was a violation of equal rights and equal protection, that these sort of like victims of negligence were not compensated to the full extent of the law, like some other people in some other areas that are injured and everything like that. So it was a very cogent and astute decision that our Supreme Court reached, and I'm very grateful that they did.
For a lifelong injury, the future costs are the part nobody knows how to price. And I know you went into a little bit of detail on this, but how are future medical bills and life care costs valued against a hospital?
Yes, actually, we do know how to price them. So that's the good news for everybody out there, is a lot of people don't, but we do at the Grife Law Firm. So basically, the way that this is done is you hire life care plan experts. These are doctors. Sometimes non-doctors do life care plans. We use doctors. We use MD physicians to do these sort of analyses. So basically, what these doctors do is they specialize in treating these sort of catastrophic injury patients, okay? They're physiatrists. There's different specialties that do life care plans, okay? And they are able to elucidate, because one of the things, believe it or not, that's really up for debate in catastrophic injury cases is life expectancy. Because the longer the patient lives, the more money it's going to take to get them through so that they have the proper care, attendant care, medical equipment that they need for their whole lives. So the defendant hospital, a lot of times, will hire these conservative, these life care planners that they know are going to give the patient a very short lifespan so that they could pay less money out, right? But a good and fair life care planner is going to say, hey, look, we understand that this patient needs to be cared for the rest of their life. And if the money runs out, they can't come back because you sign a release or you get a judgment from a jury and that's it. You can't come back 10, 15 years later and say, hey, we live longer than the defense life expectancy doctor said, so we need more. Can't do it. So the life care planners will give a good, fair estimation that we retain of the patient's life expectancy. And then they're specialized doctors who will understand they're going to need transportation vans. They're going to need around-the-clock care. They're going to need gauze pads and needles, and they're going to need medications, and they're going to need equipment at their home to monitor their heart or whatever it is, specialized hospital beds, or they're going to need to go to a top-level facility so that they could get proper care for the rest of their lives. So these life care planners will work in conjunction with sometimes other specialists and other doctors and nurses and attendant care. And frankly, they'll get quotes. They'll call 3 or 4 different companies and say, what do you charge? This is the level of care that this patient's going to need. What do you charge for that? And then put that in their report so they have evidence if they didn't just pull these numbers out of thin air. And then once you have the life expectancy and you have dollar for dollar, the medical, nursing, attendant, medical equipment, all of those costs for the whole lifetime of the patient that's been wrongfully harmed, catastrophically harmed, then you can do your life care plan and you could price all of these items out as line items, extrapolate that over the patient's lifetime, and there you have your future medical costs. But what gets even more interesting is then you have to break it down into present money value, which basically says if we need $10 million, but I gave you $8 million now, and you invested that properly over the length of time that the patient's going to live, what is that? How do we get to that $10 million economically? So you have to have an economist, after your life care planner who's a doctor, you then get an economist to break that down into present money value, and voila, you have your future medical costs.
Wow, that is really great insight. And that value only matters if you file in time. So let's close on deadlines, immunity, and the first step. So people assume they have years to decide, and that assumption ends cases. So how long do you have to bring a hospital negligence claim under FS 9511?
Yeah, so the statute of limitations in Florida for hospital negligence and medical negligence claims is generally 2 years from the date of the incident where you were harmed. It can, under the delayed discovery doctrine, in some cases, be 4 years. And if you're dealing with a child, it could be potentially even longer. But for the most part, it's 2 years. But if you don't recognize the harm inflicted, let's just say there's a misdiagnosis, and you don't find out about the condition that was misdiagnosed until months and months later, then the law says that's when the statute of limitations would start from the date that you discovered the misdiagnosis. But again, a lot of times that's even capped at 4 years from the date of the initial incident. So that's why it's really important. And I can't emphasize this enough. If you feel like you were the victim or you suffered a medical malpractice event, then call an experienced medical malpractice lawyer immediately. The consultation is always free. You have nothing to lose. And get an expert opinion for these highly technical, legal, and medical issues. It's very important. And again, you are on a little bit of a truncated time frame. 2 years from the date of the incident, up to 4 years if there's some kind of delayed discovery for most cases. Yeah, if you suffered a serious harm due to a hospital, employee, event, doctor negligence, whatever, give me a call and let's talk about it.
And when the hospital is a public one, sometimes the rules change in ways families never expect. So what is sovereign immunity and how does it limit claims against a public hospital in Florida?
Yeah, so sovereign immunity is one of those things that really hurts the patient. So there's a lot of public healthcare systems in the state of Florida, particularly in Broward County. There's Broward Health, and there's some in Miami-Dade, and there's really probably in almost every county, there's some level of government run or government funded hospitals or clinics, et cetera. And when those hospitals do harm, and if they're employees that are actually employees, it doesn't mean necessarily that they practice medicine there, but a lot of times they are employees of the public system. Then sovereign immunity caps the damages that you could recover. Now we're trying in Florida, I believe, to raise those to $350,000, and we'll see if that legislation actually goes through and passes. But in medical malpractice cases that are typically worth many hundreds of thousands of dollars, if not millions and millions of dollars, because of the level of harm suffered, you're for the most part capped at around 200,000. Again, it could be bigger because we're trying to raise the sovereign immunity limits, but it's a real problem because these public hospitals can cause catastrophic harm to their patients. And under the sovereign immunity laws, those patients are unjustifiably capped. So if you have the option, I would not go to any sort of public hospital or facility. And that's one of the reasons why.
So for a family that suspects a hospital harmed them, the first move is the hard part. If you suspect a Boca Raton or Palm Beach County hospital harmed your family, what is the first step?
First step is to call an attorney, but make sure your attorney practices medical malpractice and ask that attorney, how many medical malpractice cases do you have right now? How many have you done in your career? Have you gone to trial on any medical malpractice cases? Carefully vet these lawyers and make sure that they're real medical malpractice practitioners who do this sort of work and who know the law. Okay. So reach out to an attorney. The consultation's free. Go through everything with them. The good, the bad, the ugly, all of it. What happened? What brought you to the hospital? Who do you think let you down? Why do you think they let you down? What harms have you suffered? This is going to give you a good kind of analysis of whether or not you have a medical malpractice case, whether it's worth your time, what to reasonably expect in terms of how long it's going to take, what sort of recovery can you expect financially for the damage you've suffered. So call a really experienced medical malpractice lawyer who's going to take great care of you.
Thank you so much for going over that full arc from who the defendant is to the first call a family should make. So before we wrap, Mike, what is the one thing you want a family in Boca Raton to remember if they think a hospital harmed someone they love?
Yeah, call a very experienced medical malpractice lawyer like the Grife law firm, like Mike Grife. I do these sort of cases. This is my bread and butter. This is my specialty. This is what I love to do. I love taking, and I think, maybe put on this earth in a lot of ways to do these sort of cases. I think that the lawyers who tend to do these sort of cases have a unique understanding of the medicine and the standard of care and the interplay between the medicine and the law. hire a really experienced, dedicated, passionate medical malpractice specialist for your case. Reach out and get a consultation, because the last thing you want is that so much time went by. Perhaps you've blown the statute of limitations or things like that. So very expeditiously, reach out, speak to a lawyer, get a lay of the land, and the lawyer might tell you, hey, we need to request this or we need to request that. There's all kinds of benefits under the law and all kinds of information you're entitled to discover from these hospitals that the average patient out there doesn't know about. So the lawyer can say, hey, we can get this document and that document and things of that nature. So if you feel you've been harmed by a hospital, definitely call the Grife Law Firm. Definitely speak with me, Mike Grife. Let's go through it. Let's go through all the facts, circumstances, and give you some real deal legal analysis to put the law on your side.
If a hospital in Boca Raton or anywhere in Florida harmed your family, the consultation is free and there is no fee unless there is a recovery. So call the Grife Law Firm at 561-998-0770 or visit thegrifelawfirm.com to set up your free case review. Thanks for listening to Boca Raton Injury Law with Mike Grife. We will see you on the next episode.